Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of negotiable instruments, and that too in relation to matters involving liability of director of the company for the offence under section 141 of the Negotiable Instruments Act. To know more about it, please watch the video fully. If you feel that it's useful to you, please like, share and comment, and never ever forget to subscribe to it. And further click on the bell icon next to the subscribe button.
Hi everyone. In this video, I'll be dealing with the latest Supreme Court judgment. So, in the important judgment titled Sunita Palita and Others versus PANCHAMI Stone Quarrry pronounced on 1st August 2022, the Supreme Court has held that it is not necessary to make an averment that a managing director or a joint managing directors were in charge of and responsible for the conduct of the business of a company to make them accused under section 141 of the Negotiable Instruments Act 1881. The facts of the case would be that the respondent filed a petition of complaint against the appellants under section 138/141 of the NI Act with allegation that the appellants, being the accused numbers 3, 4 and 5, were directors of the company. The appellants filed a criminal revisional application in Calcutta High Court under section 482 of the CRPC, praying that the proceedings under section 138 read with section 141 of the NI Act pending in the court of the judicial magistrate be quashed, and pending such order, all proceedings in the said case be stayed. By the impugned judgment and order, the single bench rejected the application filed under section 482 of the CRPC. Being aggrieved, the appellants have approached this court alleging that the appellants claim that they are independent, non-executive directors of the company who are in no way responsible for the day-to-day affairs of the company. The Supreme Court has held that section 482 of CRPC protects the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under the CRPC or to prevent abuse of the process of any court or otherwise secure the ends of justice. While it is true that the inherent jurisdiction under section 482 should be exercised sparingly, carefully and with caution, and only when such exercise is justified by the tests specially laid down in the section, the court is duty bound to exercise its jurisdiction under section 482 of CRPC when the exercise of such power is justified by the tests laid down in the said section. Jurisdiction under section 482 of the CRPC must be exercised if the interest of the justice so requires. The High Court rightly held that when a complaint was filed against the director of the company, a specific averment that such person was in charge of and responsible for the conduct of business of the company was an essential requirement of section 141 of the NI Act. The High Court also rightly held that merely being a director of the company is not sufficient to make the person liable under section under section 141 of the NI Act, and the requirement of section 141 of the NI Act was that the person sought to be made liable should be in charge of and responsible for the conduct of the business of the company. This has to be averred as a fact. The High Court also rightly held that the managing director or the joint managing director would admittedly be in charge of the company and responsible to the company for the conduct of its business by virtue of the office they hold as managing director or the joint managing director. These persons are in charge of the responsible for the conduct of the business of the company, and they get covered under section 141 of the NIA. A signatory of a check is clearly liable under section 138/141 of the NI Act. The High Court, however, failed to appreciate that none of these appellants were managing director or joint managing director of the company, nor were they signatories of the check which was dishonored. The High Court observed rightly that the laudable object of preventing bouncing of checks and sustaining the credibility of commercial transactions, resulting in enactment of Section 138 and 141 of NI Act has to be borne in mind. A complaint should also not be read with a pedantically hyper-technical approach to deny relief under Section 482 of the CRPC to those impleaded as accused, who do not have any criminal liability in respect of the offence alleged in the complaint. The provisions of Section 138 and 141 of the NIA create a statutory presumption of dishonesty against those covered by Section 138 and 141 of the NI Act and expose them to criminal liability if payment is not made within the statutory period, even after the issue of the notice. There can be no doubt that in deciding the criminal revisional application under Section 482 of the CRPC for quashing a proceeding under Section 138 and 141 of the NIA, the laudable object of preventing bouncing of checks and sustaining the credibility of commercial transactions resulting in enactment of sections has to be borne in mind. The provisions of Section 138 and 141 of NIA create a statutory presumption of dishonesty on the part of the signatory of the check, and when the check is issued on behalf of a company, also those persons in charge of or responsible for the company or business of the company. Every person connected with the company does not fall within the ambit of Section 141 of the NIA. A director of a company who was not in charge or responsible for the conduct of the business of a company at a relevant time will not be liable under those provisions. Liability depends on the role one plays in an affairs of the company and not on the designation or status alone, as held by this court in SMS Pharmaceuticals Limited versus Sunita Bhalla, reported in 2005, 8 SCC 89. So the High Court correctly observed that three categories of persons were covered by Section 141 of NI Act. The company who committed the offence was, as alleged, everyone who is in charge of or was responsible for the business of the company, and any other person who was a director or the manager or the secretary or officer of the company with whose convenience or due to whose neglect the company committed the offence. Even though the High Court depreciated the adoption of hyper-technical approach in construing the pleadings to quash criminal proceedings, the High Court adopted a hyper-technical approach in rejecting the application under Section 482 of CRPC on a cursory reading of the formalistic pleadings in the complaint, endorsing the contents of Section 141 of NIA without any particulars. What the High Court overlooked was the contentions of these appellants that they were non-executive independent directors of the company based on unimpeachable matters on record. The High Court observed that in the petition, it had specifically been averred that all the accused persons were responsible and liable for the whole business management of the company, and took the view that the averments in the complaint were sufficient to meet the requirements of the Section 141 of the Negotiable Instruments Act. In any event, there could be no justification for not dispensing with the personal appearance of the appellants when the company had entered appearance through an authorized officer. Therefore, the High Court erred in the law in not exercising its jurisdiction under Section 482 of CRPC in the facts and circumstances of this case to grant relief to the appellants. Thus, the judgment and order of the High Court is set aside. Criminal case pending under Section 138 and 141 of the NIA in the Court of Judicial Magistrate is quashed insofar as the appellants are concerned. It is made clear that the proceedings may continue against the other accused in the criminal case, including in particular an accused company, its managing directors, additional managing directors, and or the signatories of the check in question. So that's it for this video. Hope you'll find this judgment helpful. Thank you.